Question 1. Benchmark analysis indicates that immigration attorneys practicing in California must ensure their clients' N-400 applications for naturalization are complete and truthful. If an applicant for U.S. citizenship has a past arrest for a minor offense that was dismissed over 15 years ago, what is the most appropriate course of action for their attorney to take regarding this information on the N-400? Option A. Advise the applicant to fully disclose the arrest and dismissal on the N-400, providing any available documentation, and prepare to explain the circumstances if asked by USCIS. Option B. Instruct the applicant to only disclose the arrest if USCIS specifically asks about arrests, as the dismissal makes it irrelevant for the N-400. Option C. Focus on the applicant's current good moral character and residency, assuming the old, dismissed arrest is not a material fact for the N-400. Option D. Advise the applicant to omit the arrest from the N-400, as it was dismissed long ago and is unlikely to affect their eligibility. Correct answer is A. Advise the applicant to fully disclose the arrest and dismissal on the N-400, providing any available documentation, and prepare to explain the circumstances if asked by USCIS. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires an immigration attorney to navigate the complexities of the N-400 application process while adhering strictly to U.S. immigration law and ethical obligations. The attorney must ensure the applicant's disclosures are accurate and complete, as any misrepresentation or omission can have severe consequences, including denial of the application and potential future immigration issues. The challenge lies in balancing the attorney's duty to zealously represent their client with the absolute requirement of truthfulness to the U.S. government. Correct approach analysis. The best professional practice involves thoroughly reviewing the applicant's N-400 application with them, specifically addressing any potential areas of concern or past issues that might require explanation or documentation. This approach prioritizes full disclosure and accuracy, aligning with the attorney's ethical duty to the client and the legal requirement of truthfulness to USCIS. By proactively identifying and preparing for potential challenges, the attorney ensures the application is as complete and accurate as possible, minimizing the risk of misrepresentation. This aligns with 8 CFR Section 1001(1)(f), which defines misrepresentation as a false representation of a material fact, and 8 U.S. Code Section 1325, which prohibits knowingly and willfully making false statements in an immigration matter. Incorrect approaches analysis. One incorrect approach involves advising the applicant to omit any information that might be perceived negatively, even if it is truthful. This directly violates the attorney's ethical duty of candor to the tribunal and the legal requirement for truthful statements to USCIS. Omitting material facts constitutes misrepresentation under immigration law, which can lead to severe penalties. Another incorrect approach is to assume that because an issue occurred many years ago, it is no longer relevant and does not need to be disclosed on the N-400. The N-400 requires disclosure of certain past events regardless of their age, and failure to disclose can be considered a material misrepresentation. The attorney's role is to understand the specific disclosure requirements of the N-400 and advise the client accordingly, not to make subjective judgments about relevance based on time. A further incorrect approach is to focus solely on the applicant's eligibility for citizenship without adequately addressing the disclosure requirements of the N-400 form itself. While eligibility is paramount, the N-400 is a sworn statement, and its accuracy and completeness are critical. An attorney must guide the client through the specific questions and disclosure obligations of the form, not just general eligibility criteria. Professional reasoning. Professionals should adopt a systematic approach to client representation that prioritizes accuracy and compliance. This involves a thorough understanding of the relevant legal framework, in this case, U.S. immigration law and USCIS regulations, a detailed review of the client's personal history, and proactive identification of any potential issues that may arise during the application process. The attorney must educate the client on their disclosure obligations and the consequences of misrepresentation. When in doubt about disclosure, it is always best to err on the side of full disclosure and provide supporting documentation, rather than risk an allegation of misrepresentation. Question 2. Benchmark analysis indicates that an immigration attorney in California is preparing an N-400 application for a client who has a minor arrest from over 10 years ago that did not result in a conviction. The client states that they believe this incident is irrelevant and should not be disclosed. What is the most ethically and legally sound approach for the attorney to take? Option A. Thoroughly review the applicant's entire history with them. Explain the specific N-400 questions regarding arrests and diversions, and advise them on how to accurately and truthfully answer each question, including the past arrest. Option B. Advise the client to omit the past arrest from the N-400 application, as it did not result in a conviction and occurred many years ago. Option C. Tell the client to answer no to questions about arrests if they believe the incident will not negatively impact their application. Option D. Instruct the client to only disclose arrests that resulted in convictions, as this is the most significant information for USCIS. The correct answer is A. Thoroughly review the applicant's entire history with them. Explain the specific N-400 questions regarding arrests and diversions, and advise them on how to accurately and truthfully answer each question, including the past arrest. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires an immigration attorney to navigate the complexities of the N-400 application process while adhering strictly to U.S. immigration law and ethical obligations. The attorney must ensure the applicant's disclosures are accurate and complete, as omissions or misrepresentations can have severe consequences, including denial of citizenship and potential deportation. The challenge lies in balancing the attorney's duty to zealously represent the client with the absolute requirement of truthfulness to the U.S. government. Correct approach analysis. The best professional practice involves thoroughly reviewing the applicant's entire history, including any past arrests, with the applicant, explaining the significance of each disclosure on the N-400, and advising them on how to accurately and truthfully answer each question. This approach directly aligns with the attorney's ethical duty of candor to the tribunal USCIS and the legal requirement for truthful statements on immigration applications under 8 U.S. Code Section 1451 and 18 U.S. Code Section 1001. By proactively addressing potential issues and ensuring complete disclosure, the attorney safeguards the applicant's case and upholds the integrity of the immigration process. Incorrect approaches analysis. Advising the applicant to omit information about a past arrest, even if it did not result in a conviction, is a direct violation of the requirement for truthful and complete disclosure on the N-400. This constitutes misrepresentation and can lead to the denial of the application and potential penalties for the applicant. Similarly, advising the applicant to only disclose arrests that led to convictions ignores the N-400's specific questions about arrests, charges, and diversions, regardless of outcome. Failing to explain the implications of past incidents to the applicant and simply telling them to answer no if they believe it won't affect the outcome is negligent and unethical, as it abdicates the attorney's responsibility to ensure accurate and informed responses. Professional reasoning. Professionals in this situation should employ a decision-making process that prioritizes absolute truthfulness and thoroughness. This involves 1. Understanding the specific requirements of the N-400 form and relevant U.S. immigration laws regarding disclosure. 2. Conducting a comprehensive interview with the applicant to elicit all relevant information, including past interactions with law enforcement. 3. Clearly explaining to the applicant the legal implications of their disclosures and the consequences of any misrepresentation. 4. Advising the applicant on how to truthfully and accurately answer each question on the N-400, providing supporting documentation where necessary. 5. Maintaining open communication with the applicant throughout the process. Question 3. Cost-benefit analysis shows that thoroughly reviewing and disclosing all past interactions with law enforcement, even minor or long-ago incidents, is the most prudent course of action for an applicant preparing their N-400 application for U.S. citizenship. Considering this, which approach best aligns with U.S. immigration law and ethical obligations for an applicant in California? Option A. Rely on informal assurances from friends or family that past legal issues have been cleared and do not need to be mentioned. Option B. Diligently recall and disclose all arrests, detentions, or convictions, regardless of whether charges were dismissed, expunged, or occurred many years ago, and provide all requested details. Option C. Only disclose arrests, detentions, or convictions that the applicant believes are serious enough to potentially affect their eligibility. Option D. Assume that minor offenses, or those that occurred over a decade ago, do not need to be disclosed as they are unlikely to be relevant. The correct answer is B. Diligently recall and disclose all arrests, detentions, or convictions, regardless of whether charges were dismissed, expunged, or occurred many years ago, and provide all requested details. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires an applicant to accurately and truthfully represent their personal history on a critical government form, the N-400. The challenge lies in the potential for past actions, even if seemingly minor or long ago, to have implications for eligibility. Misrepresenting information, even unintentionally, can lead to severe consequences, including denial of the application and potential future immigration issues. Therefore, meticulous attention to detail and a commitment to full disclosure are paramount. Correct approach analysis. The best professional practice involves a thorough and honest review of all past activities and experiences, regardless of how insignificant they may seem. This approach prioritizes complete and accurate disclosure on the N-400 form. Specifically, it means recalling and documenting any instances of arrest, detention, or conviction, even if the charges were dismissed, expunged, or occurred many years ago. This approach is correct because U.S. immigration law, as administered by U.S. Citizenship and Immigration Services (USCIS), requires applicants to disclose all such events. Failure to do so, even if the event itself would not have disqualified the applicant, constitutes a misrepresentation, which is a serious ground for inadmissibility and denial of citizenship. Honesty and transparency are foundational ethical principles in any application process for government benefits or status. Incorrect approaches analysis. One incorrect approach involves assuming that minor or old offenses do not need to be disclosed. This is professionally unacceptable because USCIS requires disclosure of all arrests, detentions, or convictions, regardless of the outcome or the passage of time. The law does not provide a statute of limitations for disclosing such events on the N-400. Another incorrect approach is to only disclose offenses that the applicant believes are serious enough to warrant concern. This is also professionally unacceptable as it relies on the applicant's subjective judgment of seriousness, rather than adhering to the objective requirements of the form and U.S. immigration law. The N-400 form explicitly asks about these events, and omitting them constitutes a misrepresentation. A third incorrect approach is to rely on the advice of someone who is not a qualified legal professional or to assume that a past legal record has been cleared without official documentation. This is professionally unacceptable because it can lead to misinformation and incomplete disclosure, potentially jeopardizing the application. USCIS requires applicants to provide specific details about any such events, and informal assurances are not a substitute for accurate reporting. Professional reasoning. Professionals facing such situations should adopt a framework of, when in doubt, disclose. This means erring on the side of caution and providing all requested information, even if it seems trivial. The decision-making process should involve 1. Carefully reading and understanding every question on the N-400 form. 2. Conducting a comprehensive personal review of all past interactions with law enforcement. 3. Seeking clarification from official USCIS resources or a qualified immigration attorney if any question is unclear or if there is any uncertainty about past events. 4. Prioritizing absolute truthfulness and completeness in all responses. Question 4. Process analysis reveals that a U.S. lawful permanent resident applying for naturalization via the N-400 form in California has a history of several minor traffic citations and one arrest for a misdemeanor that was ultimately dismissed. The applicant believes these past events are insignificant and should not be included on the application. What is the most appropriate course of action for an immigration consultant assisting this applicant? Option A. Focus the N-400 application on the applicant's positive attributes and community involvement, downplaying the importance of past legal interactions and suggesting they only mention them if directly asked by USCIS during an interview. Option B. Advise the applicant to omit the minor traffic citations and the dismissed arrest from the N-400 application, as these events are unlikely to impact their eligibility for citizenship. Option C. Instruct the applicant to only disclose the arrest if charges were filed and the case resulted in a conviction, advising them to exclude traffic citations and dismissed misdemeanor charges. Option D. Thoroughly review all past interactions with law enforcement, including traffic citations and the dismissed arrest, with the applicant, explaining the legal requirement to disclose all such events on the N-400 form, regardless of their perceived significance or outcome, and assist in gathering any necessary documentation. The correct answer is D. Thoroughly review all past interactions with law enforcement, including traffic citations and the dismissed arrest, with the applicant, explaining the legal requirement to disclose all such events on the N-400 form, regardless of their perceived significance or outcome, and assist in gathering any necessary documentation. Explanation. Scenario analysis. This scenario presents a challenge in accurately and ethically completing the N-400 application for naturalization in the United States. The applicant's past interactions with law enforcement, even if minor or resolved, require careful disclosure to avoid misrepresentation, which is a serious offense under U.S. immigration law. The professional challenge lies in ensuring the applicant understands the gravity of full disclosure and in guiding them to provide accurate information without inadvertently misleading USCIS. Correct approach analysis. The best approach involves thoroughly reviewing the applicant's history with them, explaining the legal requirement to disclose all arrests, citations, and interactions with law enforcement, regardless of perceived severity or outcome. This approach ensures the applicant understands that USCIS expects complete honesty and that omissions can lead to denial of the application and potential future immigration consequences. The justification is rooted in the Immigration and Nationality Act, INA, and USCIS policy, which mandate truthful and complete answers on all applications. Specifically, 8 U.S. Code Section 1427. 4 requires that the applicant be a person of good moral character, and failure to disclose material facts can be considered a lack of good moral character. Furthermore, 8 C.F.R. Section 1001. 1F defines application to include all statements made in connection with it, emphasizing the importance of accuracy. Incorrect approach is analysis. One incorrect approach is to advise the applicant to omit minor traffic violations or incidents that were dismissed, believing they are not significant enough to report. This is a failure to comply with the explicit instructions on the N-400 form, which asks about all arrests and detentions. Omitting such information, even if seemingly minor, constitutes misrepresentation and can be grounds for denial. Another incorrect approach is to only focus on the outcome of an arrest, e.g., dismissal, without ensuring the arrest itself is disclosed. USCIS requires disclosure of the arrest, citation, or detention, regardless of whether charges were filed or if the case was resolved in the applicant's favor. Failing to disclose the event itself, even if the legal proceedings concluded favorably, is a misrepresentation. A third incorrect approach is to rely solely on the applicant's memory without actively probing for details or suggesting they gather documentation. While the applicant is responsible for the accuracy of their application, a professional assisting them has an ethical duty to guide them towards comprehensive disclosure and to encourage them to obtain records that can aid in accurate reporting. Professional reasoning. Professionals assisting applicants with the N-400 form must adopt a proactive and thorough disclosure strategy. This involves a detailed interview process, clear explanation of legal obligations, and encouragement of documentation gathering. The decision-making framework should prioritize absolute honesty and completeness, recognizing that USCIS scrutinizes all aspects of an applicant's history to determine eligibility for U.S. citizenship. The paramount consideration is adherence to U.S. immigration law and USCIS regulations, ensuring the applicant understands that any attempt to conceal or misrepresent information can have severe repercussions. Question 5. Governance review demonstrates that a U.S. immigration attorney is preparing an N-400 application for a client who has had several encounters with law enforcement in California, including one arrest for a minor offense that was later dismissed and another for a charge that was expunged. The client believes these incidents are irrelevant and should not be included on the application. What is the attorney's primary ethical and legal obligation in this situation? Option A. Advise the client to omit any arrests or charges that did not result in a conviction or were expunged, as these are generally considered minor and unlikely to impact the application. Option B. Rely on the client's assessment of relevance and proceed with the application without independently verifying the details of the dismissed or expunged charges. Option C. Focus the disclosure only on convictions, as the N-400 form primarily asks about criminal convictions and not every interaction with law enforcement. Option D. Advise the client that all arrests and charges, regardless of whether they resulted in a conviction or were expunged, must be fully disclosed on the N-400 application, and assist the client in gathering the necessary documentation to support this disclosure. The correct answer is D. Advise the client that all arrests and charges, regardless of whether they resulted in a conviction or were expunged, must be fully disclosed on the N-400 application, and assist the client in gathering the necessary documentation to support this disclosure. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires an immigration attorney to navigate the complexities of the N-400 application process while adhering strictly to U.S. immigration law and ethical obligations. The attorney must ensure the applicant's disclosures are accurate and complete, as any misrepresentation or omission can have severe consequences, including denial of the application and potential future immigration issues. The challenge lies in balancing the attorney's duty to represent the client zealously with the absolute requirement of truthfulness to the U.S. government. Correct approach analysis. The best professional practice involves thoroughly reviewing the applicant's entire history, including any past interactions with U.S. law enforcement, even if the applicant believes they are minor or irrelevant. This approach prioritizes full and accurate disclosure to U.S. Citizenship and Immigration Services, USCIS, as mandated by the N-400 application instructions and federal immigration law. Specifically, the N-400 requires applicants to disclose arrests, charges, and convictions, regardless of whether they resulted in a conviction or were expunged. Failing to disclose such information, even if the applicant believes it will not affect their eligibility, constitutes a material misrepresentation, which is a serious offense under U.S. immigration law. The attorney's ethical duty is to advise the client on the legal requirements and ensure all necessary information is provided, even if it might seem detrimental to the application. This proactive and comprehensive approach minimizes the risk of adverse findings by USCIS. Incorrect approaches analysis. One incorrect approach involves advising the applicant to omit any arrests or charges that did not result in a conviction or were expunged, based on the applicant's belief that they are irrelevant. This is a significant ethical and legal failure. U.S. immigration law, as reflected in the N-400 instructions, requires disclosure of all arrests and charges, regardless of the outcome. Omitting this information, even if the applicant believes it is minor, is a misrepresentation and can lead to denial of the N-400 and other severe penalties. The attorney is failing in their duty to ensure accurate disclosure to USCIS. Another incorrect approach is to only focus on convictions and ignore any arrests or charges that did not lead to a conviction. This is also a failure to comply with the explicit requirements of the N-400 form and U.S. immigration regulations. USCIS needs to be aware of all interactions with law enforcement to assess the applicant's character and eligibility. A third incorrect approach is to rely solely on the applicant's recollection without independently verifying the information or advising them on the necessity of obtaining official records. While the applicant's input is crucial, the attorney has a responsibility to ensure the accuracy and completeness of the application, which may necessitate obtaining certified court records or police reports to confirm the details of any arrests or charges. Professional reasoning. Professionals in this field must adopt a proactive and meticulous approach to N-400 applications. The decision-making process should begin with a comprehensive understanding of the N-400 requirements and relevant U.S. immigration laws. Attorneys must prioritize full and truthful disclosure to USCIS above all else, even when clients express a desire to omit information they deem insignificant. The ethical framework demands that attorneys counsel clients on the legal ramifications of non-disclosure and guide them in providing all required information. If a client is resistant to disclosing potentially problematic information, the attorney must explain the severe consequences of misrepresentation, and if necessary, consider withdrawing from representation if the client insists on a course of action that violates legal and ethical obligations. The ultimate goal is to present a complete and accurate application that allows USCIS to make an informed decision. Question 6. During the evaluation of a U.S. N-400 application for naturalization, an applicant from California recalls being briefly detained by local police several years ago due to a misunderstanding, but no charges were ever filed, and the incident did not result in a conviction. The applicant is concerned that mentioning this event might negatively impact their application. What is the most appropriate course of action for the applicant regarding this detention on their N-400 form? Option A. Only disclose the detention if it had resulted in a conviction. Option B. Omit any mention of the detention because no charges were filed and it did not lead to a conviction. Option C. Fully disclose the detention, including the circumstances, the fact that no charges were filed, and the outcome, providing any available documentation. Option D. Provide a brief, vague statement about the incident without detailing the circumstances or outcome. The correct answer is C. Fully disclose the detention, including the circumstances, the fact that no charges were filed, and the outcome, providing any available documentation. Explanation. Scenario analysis. This scenario presents a challenge because it requires an applicant to accurately recall and report past interactions with law enforcement, even if those interactions did not result in a conviction. The N-400 form is a legal document, and omissions or misrepresentations can have serious consequences, including denial of the application and potential immigration violations. The applicant's desire to present themselves in the best possible light must be balanced with the absolute requirement for truthfulness and completeness. Correct approach analysis. The best professional practice involves a complete and truthful disclosure of all requested information, regardless of the outcome of the interaction. This approach aligns with the USCIS requirement for applicants to provide accurate information on the N-400 form. Specifically, USCIS Policy Manual Volume 12, Part F, Chapter 4, Section B, 3. B states that applicants must disclose arrests, detentions, or indictments, even if no charges were filed or the charges were dismissed. This approach ensures compliance with federal immigration law and demonstrates good moral character, a key factor in naturalization. Incorrect approaches analysis. One incorrect approach is to omit any mention of the interaction because no charges were filed or the case was dismissed. This is a failure to comply with USCIS regulations, which mandate disclosure of all arrests and detentions, regardless of disposition. Such an omission can be interpreted as misrepresentation or concealment of material facts, potentially leading to denial of the N-400 application and future immigration issues. Another incorrect approach is to only disclose the interaction if it resulted in a conviction. This also violates USCIS requirements. The N-400 form specifically asks about arrests, detentions, or indictments, not solely convictions. Failing to disclose an arrest or detention simply because it did not lead to a conviction is a misrepresentation of the applicant's history. A third incorrect approach is to downplay the significance of the interaction or provide vague details when asked about it. While the applicant may not have been convicted, the fact of the arrest or detention is material information that USCIS needs to assess the applicant's eligibility. Providing incomplete or misleading information, even if not an outright lie, can still be considered a misrepresentation. Professional reasoning. Professionals assisting applicants with the N-400 form must prioritize absolute honesty and thoroughness. The decision-making process should involve a detailed review of the applicant's history, including any interactions with law enforcement, and a clear understanding of USCIS disclosure requirements. When in doubt about whether to disclose something, the safest and most ethical approach is always to disclose it and provide full details. This proactive approach minimizes the risk of misrepresentation and supports the applicant's path to citizenship. Question 7. What factors determine the eligibility of a lawful permanent resident applying for U.S. citizenship via the N-400 form when they have a past arrest in California for a misdemeanor offense that was later dismissed? Option A. The applicant's belief that the arrest was minor and unlikely to affect their eligibility. Option B. The specific nature of the misdemeanor offense, the applicant's age at the time of the arrest, the official disposition of the case dismissal, and the applicant's subsequent conduct demonstrating good moral character. Option C. The applicant's testimony that they were not guilty of the offense, regardless of official court records. Option D. The passage of a specific number of years since the arrest, without regard to the offense or its disposition. The correct answer is B. The specific nature of the misdemeanor offense, the applicant's age at the time of the arrest, the official disposition of the case dismissal, and the applicant's subsequent conduct demonstrating good moral character. Explanation: the scenario of an applicant for U.S. citizenship, N-400, having a past arrest presents a significant professional challenge for immigration practitioners. The challenge lies in accurately assessing the legal implications of the arrest and its potential impact on eligibility for naturalization, balancing the applicant's desire for citizenship with the strict requirements of U.S. immigration law. Misinterpreting the law or failing to conduct thorough due diligence can lead to severe consequences for the applicant, including denial of their application and potential deportation. The best approach involves a comprehensive review of all available documentation related to the arrest and subsequent legal proceedings. This includes obtaining certified court records, police reports, and any disposition documents. The practitioner must then meticulously analyze these records against the specific grounds for inadmissibility and ineligibility for naturalization as outlined in the Immigration and Nationality Act, INA. This involves understanding how different types of offenses, the applicant's age at the time of the offense, and the outcome of the legal proceedings, e.g., conviction, acquittal, dismissal, affect eligibility. For example, certain crimes can make an applicant permanently ineligible, while others may require a specific period of good moral character following the offense. The practitioner must also consider the applicant's overall history and their ability to demonstrate good moral character, which is a crucial element for naturalization. This thorough, fact-based, and legally grounded analysis ensures that the applicant is advised accurately and that their application, if filed, is supported by all necessary evidence and legal arguments. An incorrect approach would be to rely solely on the applicant's verbal account of the arrest without seeking official documentation. This is a significant ethical and regulatory failure because verbal accounts are often incomplete, inaccurate, or misleading, and U.S. Citizenship and Immigration Services, USCIS, requires official records to verify information. Failing to obtain these records means the application will likely be based on incomplete or false information, leading to denial and potential penalties. Another incorrect approach is to assume that an arrest without a conviction automatically means no impact on eligibility. This is a legal misinterpretation of the INA, which considers certain arrests and their circumstances, even without a conviction, when assessing good moral character or potential ineligibility. A third incorrect approach is to advise the applicant to omit the arrest from their N-400 form, even if they believe it will not affect their eligibility. This constitutes misrepresentation and can have severe consequences, including denial of the application and potential bars from future immigration benefits. Professionals should employ a systematic decision-making process that prioritizes thoroughness, accuracy, and adherence to legal and ethical standards. This involves 1. Active listening and information gathering from the applicant, but always with the understanding that official verification is paramount. 2. Proactive identification of potential red flags, such as any mention of arrests, convictions, or immigration violations. 3. A commitment to obtaining all relevant official documentation. 4. A deep understanding of the INA and relevant USCIS policy manuals concerning eligibility requirements, particularly regarding criminal history and good moral character. 5. Providing clear, legally sound advice to the applicant based on the verified facts and applicable law, including discussing potential risks and alternative strategies if eligibility is questionable. Question 8. Quality control measures reveal a discrepancy in a client's N-400 form for naturalization, specifically regarding their residential history. The client, who is applying for U.S. citizenship in California, previously lived at a temporary address for 6 months within the required 5-year continuous residence period, but this address was not listed on the form. The immigration attorney must advise the client on how to proceed. Option A. Proceed with the application without further discussion, assuming the temporary residence is too insignificant to warrant amendment. Option B. Advise the client to omit the temporary residence from the N-400, as it was not their primary dwelling. Option C. Submit the N-400 as is and hope USCIS does not discover the omission during the review process. Option D. Discuss the discrepancy with the client, explain the importance of reporting all residences, and guide them in amending the N-400 to include the temporary address, ensuring full disclosure. Correct answer is D. Discuss the discrepancy with the client, explain the importance of reporting all residences, and guide them in amending the N-400 to include the temporary address, ensuring full disclosure. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires an immigration attorney to balance their duty to their client with their obligation to uphold the integrity of the U.S. immigration system and comply with federal regulations. Misrepresenting information on an N-400 form, even if seemingly minor or unintentional, can have severe consequences for the applicant, including denial of citizenship and potential future immigration issues. The attorney must exercise careful judgment to ensure accuracy and completeness without inadvertently misleading USCIS or the applicant. Correct approach analysis. The best professional practice involves a thorough review of the N-400 application with the client, specifically addressing any discrepancies or potential areas of concern identified during quality control. This approach prioritizes open communication and client education. The attorney should explain to the client the importance of accurate reporting of all residences, even temporary ones, and the potential implications of omissions. They should then guide the client in amending the application to reflect the accurate residential history, ensuring full compliance with 8 CFR Section 316. 2A. 3, which requires continuous residence in the U.S. for at least 5 years immediately preceding the date of filing the application. This proactive and transparent method upholds the attorney's ethical duty of competence and diligence while safeguarding the client's application. Incorrect approach is analysis. One incorrect approach involves advising the client to simply omit the temporary residence from the N-400 form, arguing it was not a primary residence. This is a direct violation of the requirement for truthful and complete disclosure on all USCIS forms. Failing to report all residences, regardless of duration or perceived significance, can be construed as misrepresentation or concealment of material facts, which is grounds for denial under the Immigration and Nationality Act, in Section 316A, and can lead to penalties. Another incorrect approach is to submit the application with the omission and then hope it is not discovered during the adjudication process. This demonstrates a lack of diligence and competence, as the attorney has identified a potential issue and failed to address it proactively. This passive approach risks the client's application being denied and could expose the attorney to ethical sanctions for failing to provide adequate representation. A third incorrect approach is to proceed with the application as is, without discussing the discrepancy with the client, and assuming the temporary residence is insignificant. This bypasses the client's right to be informed about their application and the attorney's responsibility to ensure its accuracy. It also fails to acknowledge the potential for USCIS to view any undisclosed residence as a material omission, thereby undermining the integrity of the application and the attorney's professional obligations. Professional reasoning. Professionals should adopt a systematic approach to quality control. When discrepancies or potential issues arise, the first step is always to understand the facts thoroughly. This involves direct communication with the client to gather all relevant information. The next step is to assess the legal implications of these facts in light of the applicable regulations, in this case, U.S. immigration law and USCIS requirements. Based on this assessment, the professional should then determine the most ethical and legally compliant course of action, which invariably involves transparency with the client and accurate representation to the government agency. Question 9. The control framework reveals that a U.S. lawful permanent resident applying for naturalization in California has an arrest record from over 10 years ago that was subsequently expunged. The applicant believes that since the record is expunged, they are not required to disclose this arrest on their N-400 application for naturalization. Which approach best upholds the applicant's obligation to USCIS? Option A. Provide a general statement on the N-400 application indicating that all legal matters have been resolved without detailing the specific arrest. Option B. Fully disclose the arrest and its expungement on the N-400 application, providing a brief explanation of the circumstances. Option C. Disclose the arrest only if specifically questioned about it during the naturalization interview. Option D. Do not disclose the arrest on the N-400 application, as the record has been expunged and is no longer considered a conviction. Correct answer is B. Fully disclose the arrest and its expungement on the N-400 application, providing a brief explanation of the circumstances. Explanation. The control framework reveals a common challenge in immigration applications, ensuring complete and accurate disclosure of all relevant information to U.S. Citizenship and Immigration Services, USCIS. This scenario is professionally challenging because the applicant's failure to disclose a past arrest, even if expunged, can be interpreted as an attempt to conceal material facts, potentially impacting their eligibility for naturalization under the U.S. Immigration and Nationality Act. In A, the applicant's intent is a key factor, but USCIS requires full disclosure regardless of the outcome of the legal proceedings. Careful judgment is required to navigate the applicant's desire to present themselves favorably against the legal obligation to be truthful and comprehensive. The best approach involves proactively and fully disclosing the arrest and its disposition to USCIS, even though the record was expunged. This approach aligns with the applicant's obligation to provide truthful and complete information on the N-400 form, as required by 8 CFR Section 338. 1a, and the general principles of good moral character under INA Section 101. F. By disclosing the arrest and explaining the circumstances and the expungement, the applicant demonstrates honesty and transparency, allowing USCIS to make an informed decision. This proactive disclosure mitigates the risk of the application being denied due to concealment of material facts, which could be viewed as a lack of good moral character. An incorrect approach is to rely solely on the expungement of the arrest record as a reason not to disclose it. This fails to acknowledge that USCIS requires disclosure of all arrests and convictions, regardless of whether they were pardoned, annulled, or expunged, as per USCIS policy guidance. The expungement does not erase the event itself for immigration purposes. Another incorrect approach is to only disclose the arrest if specifically asked about it during an interview. This is a reactive strategy that misses the opportunity for proactive disclosure on the N-400 form, which is the primary document for conveying information to USCIS. Failing to disclose on the form itself can be seen as an omission from the outset. A further incorrect approach is to provide a vague or misleading description of the arrest, hoping it will not be noticed. This constitutes misrepresentation and a lack of candor, which are serious ethical and legal violations that can lead to denial of the N-400 and potential immigration consequences. Professionals should employ a decision-making framework that prioritizes full and honest disclosure in immigration matters. This involves thoroughly reviewing the applicant's history, understanding the specific disclosure requirements of USCIS forms, and advising the applicant on the legal implications of both disclosure and non-disclosure. The guiding principle should be to provide USCIS with all necessary information to make a fair and accurate assessment of the applicant's eligibility, even if that information might seem unfavorable at first glance. Question 10. The evaluation methodology shows that a U.S. naturalization applicant, a resident of California, has earned income from a rental property in Mexico over the past 5 years. The applicant has provided bank statements showing the income in Mexican pesos, MXN, and has also provided records of the exchange rates at the time of each deposit. To accurately report this income on the N-400 form, which of the following calculation methods would best ensure compliance with U.S. reporting requirements? Option A. Calculate the total Mexican pesos earned over the 5 years and convert this lump sum to U.S. dollars using the average exchange rate for the most recent year. Option B. Report only the portion of the Mexican income that was converted to U.S. dollars and transferred to a U.S. bank account. Option C. Convert each deposit of Mexican pesos to U.S. dollars using the specific exchange rate on the date of each deposit, as provided by the applicant's records. Option D. Estimate the U.S. dollar equivalent of the income based on the applicant's general knowledge of the property's profitability in Mexican pesos. The correct answer is C. Convert each deposit of Mexican pesos to U.S. dollars using the specific exchange rate on the date of each deposit, as provided by the applicant's records. Explanation. The evaluation methodology shows a scenario where an applicant for U.S. citizenship through naturalization, Form N-400, has a complex financial history involving multiple foreign bank accounts and significant currency exchange transactions. This presents a professional challenge, because accurately reporting all income and assets, especially those generated and held abroad, requires meticulous attention to detail and a thorough understanding of U.S. tax and reporting obligations. Failure to do so can lead to misrepresentation on the N-400 form, potentially jeopardizing the application and future immigration status. Careful judgment is required to ensure full compliance with U.S. laws and regulations, particularly those related to income disclosure and the reporting of foreign financial assets. The best approach involves a comprehensive review of all financial records, including bank statements, transaction histories, and any tax filings from foreign jurisdictions. This includes calculating the US dollar equivalent of all foreign income and assets at the time of receipt or acquisition, using reliable historical exchange rates. For instance, if an applicant received rental income from a property in Canada over several years, each year's income must be converted to USD using the average exchange rate for that specific year, or the rate on the date of receipt if readily available and consistently applied. This detailed calculation and reporting ensures that the N-400 accurately reflects the applicant's financial standing and compliance with U.S. tax laws, as required by the Immigration and Nationality Act, INA, and relevant IRS regulations. The INA mandates that applicants provide truthful and accurate information on their N-400 application. Misrepresenting income or assets, even unintentionally due to poor record keeping, can be considered a failure to meet the good moral character requirement, which is a prerequisite for naturalization. An incorrect approach would be to estimate foreign income based on general knowledge or to only report income that was repatriated to the U.S. This fails to comply with the requirement to report all income earned, regardless of where it is held or how it is used. U.S. tax law generally taxes income earned by U.S. citizens and residents, and for naturalization purposes, accurate reporting of income history is crucial to demonstrate good moral character and adherence to laws. Another incorrect approach would be to use the current exchange rate for all past transactions without considering the historical rates at the time the income was earned or assets were acquired. This can lead to significant inaccuracies in the reported amounts, potentially understating or overstating income and assets, and thus misrepresenting the applicant's financial history. Professionals should adopt a systematic decision-making process that prioritizes accuracy and full disclosure. This involves 1. Gathering all relevant financial documentation. 2. Understanding the specific reporting requirements for foreign income and assets under U.S. law, including IRS regulations and any specific instructions on the N-400 form. 3. Performing precise calculations using appropriate historical exchange rates. And 4. Clearly documenting all calculations and the sources of information used. If there is any uncertainty, consulting with a qualified tax professional or immigration attorney is advisable to ensure compliance. Question 11. Stakeholder feedback indicates that applicants for U.S. citizenship through the N-400 form often seek ways to simplify their application process. When assisting an applicant who has minor inconsistencies between their travel records and their stated dates of departure and return on the N-400 application for naturalization in California, what is the most appropriate course of action? Option A. Accept the applicant's assurance that the discrepancies are minor and proceed with the N-400 application without further investigation or disclosure of the inconsistencies. Option B. Suggest the applicant round the travel dates to align with their stated departure and return dates on the N-400 application. Option C. Thoroughly review all travel records and advise the applicant on the necessity of accurately disclosing any discrepancies and providing a truthful explanation to USCIS. Option D. Advise the applicant to omit the travel dates that cause the discrepancy from the N-400 application to avoid complications. The correct answer is C. Thoroughly review all travel records and advise the applicant on the necessity of accurately disclosing any discrepancies and providing a truthful explanation to USCIS. Explanation. Scenario analysis. This scenario is professionally challenging because it requires balancing the applicant's desire for a streamlined process with the absolute requirement of providing accurate and complete information to U.S. Citizenship and Immigration Services (USCIS) during the N-400 application. Misrepresenting information, even if seemingly minor or intended to expedite, can have severe consequences, including denial of the application and potential future immigration issues. The applicant's perception of minor discrepancies versus USCIS' strict interpretation of truthfulness is a key point of friction. Correct approach analysis. The best professional approach involves thoroughly reviewing all provided documentation and cross-referencing it with the applicant's statements on the N-400 form. This includes verifying dates of travel, employment history, and any other biographical data. If discrepancies are found, The professional must advise the applicant on the importance of disclosing these accurately and assist them in preparing a clear and truthful explanation for USCIS. This aligns with the ethical duty to uphold the integrity of the immigration process and the legal requirement under U.S. immigration law to provide truthful information on all applications. The N-400 specifically requires the applicant to swear under penalty of perjury that the information provided is true and correct. Any attempt to gloss over or omit material facts, even if perceived as minor by the applicant, violates this oath. Incorrect approach is analysis. One incorrect approach is to simply accept the applicant's assurance that the discrepancies are minor and proceed with the application as is, without further investigation or disclosure. This fails to uphold the professional's duty to ensure the accuracy of the application and could lead to the applicant inadvertently committing perjury. It also ignores the potential for USCIS to discover these discrepancies during their review, which could result in denial and further scrutiny. Another incorrect approach is to advise the applicant to omit the information that causes the discrepancy, believing it will simplify the process. This is a direct violation of U.S. immigration law, which mandates full and truthful disclosure. Omitting material facts is considered misrepresentation and can have severe penalties. A third incorrect approach is to suggest the applicant round dates or figures to create consistency, even if it means deviating from the actual facts. This is also a form of misrepresentation. U.S. immigration law requires exact dates and factual information. Rounding or approximating without explicit USCIS guidance or a clear, truthful explanation for the approximation is unacceptable. Professional reasoning. Professionals assisting applicants with the N-400 form must adopt a proactive and meticulous approach. This involves a comprehensive review of all submitted documents and a direct conversation with the applicant about any potential inconsistencies. The decision-making process should prioritize transparency and accuracy, always guiding the applicant towards full compliance with U.S. immigration laws and USCIS regulations. If an applicant is resistant to providing accurate information or disclosing discrepancies, the professional must clearly explain the legal ramifications and ethical obligations, and if necessary, decline to represent the applicant if they insist on misrepresentation. The ultimate goal is to ensure the application is truthful and complete, thereby protecting the applicant from future immigration complications. Question 12. Strategic planning requires an applicant for U.S. naturalization in California to accurately and completely disclose all relevant information on their N-400 form. Considering the applicant has traveled to their country of origin multiple times since becoming a lawful permanent resident, what is the most appropriate course of action to ensure compliance with U.S. immigration law? Option A. Only disclose travel to the applicant's country of origin if specifically asked about it during the naturalization interview. Option B. Omit details about travel to the applicant's country of origin, assuming USCIS will not focus on this aspect of the application. Option C. Provide a general statement about having traveled abroad without specifying destinations or dates to keep the application concise. Option D. Fully disclose all travel history to the applicant's country of origin on the N-400 form, and be prepared to provide any supporting documentation requested by USCIS. The correct answer is D. Fully disclose all travel history to the applicant's country of origin on the N-400 form, and be prepared to provide any supporting documentation requested by USCIS. Explanation. This scenario is professionally challenging because it requires balancing the applicant's desire for a swift process with the absolute requirement of providing accurate and complete information to U.S. Citizenship and Immigration Services (USCIS) during the N-400 application. Misrepresenting information, even if seemingly minor or unintentional, can have severe consequences, including denial of the application and potential immigration penalties. Careful judgment is required to ensure all information is truthful and verifiable, adhering strictly to the legal framework governing naturalization. The best approach involves diligently gathering all necessary documentation and truthfully answering every question on the N-400 form, even if it means a longer processing time. This includes proactively addressing any potential discrepancies or complexities with USCIS, such as explaining any past travel or employment issues that might appear unusual. This approach is correct because it aligns directly with the statutory requirements for naturalization, which mandate truthfulness and completeness in all applications submitted to USCIS. Specifically, Section 316 of the Immigration and Nationality Act, (INA), requires applicants to demonstrate good moral character, which is undermined by any form of misrepresentation. Providing accurate information ensures compliance with the oath of allegiance, which requires renouncing allegiance to any foreign state and supporting the Constitution and laws of the United States. An incorrect approach involves omitting information about past travel to the applicant's country of origin, even if the applicant believes it is irrelevant or might complicate the application. Failure to disclose material facts constitutes misrepresentation, violating the good moral character requirement and potentially leading to denial. Another incorrect approach is to assume that USCIS will overlook minor inconsistencies or that the applicant can explain them later without proactively disclosing them. This demonstrates a lack of diligence and a misunderstanding of the USCIS review process, which relies on the submitted application as the primary source of information. Failing to be upfront about any potential issues, such as a prior arrest that was later dismissed, is also an incorrect approach. While a dismissed arrest may not prevent naturalization, failing to disclose it on the N-400 form is a direct violation of the requirement to answer all questions truthfully and completely, and can be interpreted as an attempt to conceal information. Professionals should employ a decision-making framework that prioritizes accuracy and full disclosure. This involves a thorough review of the applicant's history, identifying any potential areas of concern, and preparing to provide complete and truthful explanations supported by documentation. The process should always begin with understanding the applicant's complete history, and then meticulously matching that history to the questions on the N-400 form, ensuring no detail is overlooked or misrepresented. When in doubt about how to present information, seeking clarification from USCIS or consulting with an immigration attorney is the most prudent course of action. Question 13. The monitoring system demonstrates a pattern of delayed processing for a specific category of Form N-400, application for naturalization, in the California Service Center. What is the most effective and compliant method for addressing this systemic issue? Option A. Disregard the monitoring system's alerts for these Form N-400 applications, attributing the delays to normal fluctuations in workload. Option B. Initiate a targeted review of the flagged Form N-400 applications to identify common documentation gaps, procedural holdups, or potential internal processing inefficiencies, and then implement corrective actions based on the findings. Option C. Send standardized requests for additional evidence to all applicants whose Form N-400 applications have been flagged, assuming the delay is solely due to applicant omissions. Option D. Immediately escalate all flagged Form N-400 applications to senior management for urgent review and resolution, without prior individual case assessment. Correct answer is B. Initiate a targeted review of the flagged Form N-400 applications to identify common documentation gaps, procedural holdups, or potential internal processing inefficiencies, and then implement corrective actions based on the findings. Explanation. The monitoring system demonstrates a critical need for proactive case management to ensure timely and accurate processing of immigration applications. This scenario is professionally challenging because delays or errors in processing can have significant consequences for applicants, impacting their ability to work, travel, or establish permanent residency in the United States. The integrity of the immigration system relies on efficient and compliant operations. The best approach involves a systematic review of the flagged cases to identify the root cause of the delays. This includes verifying that all required documentation has been submitted, confirming that no additional information is pending from the applicant, and assessing whether internal processing bottlenecks exist. This method is correct because it directly addresses the operational inefficiencies identified by the monitoring system, adhering to the U.S. Citizenship and Immigration Services (USCIS) guidelines for case management and processing standards. It prioritizes accuracy and applicant fairness by ensuring that cases are not stalled due to oversight or procedural issues, thereby upholding the principles of due process and efficient administration of immigration laws. An incorrect approach would be to simply escalate all flagged cases to a supervisor without initial investigation. This fails to address the underlying issues and creates unnecessary work for supervisors, potentially leading to further delays. It bypasses the established procedural steps for case resolution and does not demonstrate responsible case management. Another incorrect approach is to assume the flagged cases are all due to applicant error and send automated requests for additional evidence without verification. This is procedurally unsound, as it does not account for potential USCIS processing errors or missing information on the agency's end. It can lead to applicant frustration and further delays, and it does not align with the requirement for thorough and individualized case review. A further incorrect approach would be to ignore the monitoring system's alerts, assuming they are minor anomalies. This is a direct violation of professional responsibility and USCIS operational directives, which mandate attention to system-generated flags indicating potential processing issues. Such inaction can lead to significant backlogs and negatively impact the USCIS ability to fulfill its mission. Professionals should employ a decision-making framework that begins with understanding the system's alerts, conducting a thorough and objective investigation of flagged cases, identifying root causes, implementing corrective actions, and documenting all steps taken. This ensures accountability, promotes continuous improvement, and upholds the integrity of the immigration process. Question 14. The efficiency study reveals a need to expedite the N-400 application process for a client applying for U.S. citizenship in California, considering the potential for USCIS to request additional documentation or clarification. Which strategy best balances efficiency with regulatory compliance? Option A. Conduct a comprehensive pre-application review to identify and proactively address any potential discrepancies or missing information in the client's supporting documents, ensuring all details are consistent and verifiable before submission. Option B. Advise the client to omit any details or documents that might be perceived as sensitive or could potentially lead to further USCIS scrutiny, even if they are truthful. Option C. Recommend withholding any supporting documents that are not explicitly requested on the N-400 form, even if they could help clarify potential ambiguities. Option D. Suggest the client provide vague or generalized answers to questions that might invite deeper investigation, aiming to avoid extensive follow-up inquiries. The correct answer is A. Conduct a comprehensive pre-application review to identify and proactively address any potential discrepancies or missing information in the client's supporting documents, ensuring all details are consistent and verifiable before submission. Explanation. The efficiency study reveals a need to streamline the N-400 application process for a client. This scenario is professionally challenging because it requires balancing the applicant's desire for a swift resolution with the absolute necessity of providing accurate and complete information to U.S. Citizenship and Immigration Services USCIS. Misrepresenting information or omitting details, even with the intention of speeding up the process, can lead to severe consequences, including application denial, future immigration issues, and potential criminal charges. Careful judgment is required to ensure that any process optimization strictly adheres to USCIS regulations and ethical obligations. The best approach involves a thorough review of the applicant's existing documentation and a proactive identification of any potential discrepancies or missing information that USCIS might question. This includes cross-referencing all provided documents and ensuring consistency across the application. By addressing these issues upfront, the applicant can submit a more robust and complete application, minimizing the likelihood of USCIS requests for further evidence or interviews that would delay the process. This method aligns with the ethical duty to represent clients truthfully and diligently, ensuring all information provided to USCIS is accurate and verifiable, as mandated by the Immigration and Nationality Act, INA, and USCIS policy. An approach that involves omitting information that might be perceived as negative or could lead to additional scrutiny, even if technically true, is professionally unacceptable. This constitutes a misrepresentation of facts to USCIS, violating the INA's prohibition against false statements and the ethical obligation to present a complete and truthful application. Similarly, advising the applicant to provide vague or misleading answers to questions with the goal of avoiding detailed examination is unethical and can be interpreted as aiding in the submission of a fraudulent application. Furthermore, suggesting that the applicant withhold documents that, while not explicitly requested, could clarify potential ambiguities in the application, undermines the principle of full disclosure and can lead to delays or denial when USCIS eventually requests them. Professionals should employ a decision-making framework that prioritizes accuracy, completeness, and adherence to all USCIS requirements. This involves a detailed understanding of the N400 application-specific questions and the underlying legal and regulatory framework. When faced with potential inefficiencies, the focus should always be on identifying and resolving them through legitimate means, such as gathering additional supporting evidence or clarifying ambiguities with the applicant, rather than through omission or misrepresentation. The goal is to facilitate a smooth adjudication by presenting a clear and truthful case to USCIS. Question 15. Benchmark analysis indicates that immigration attorneys in California often face challenges in accurately assessing client eligibility for U.S. citizenship through naturalization. Considering the N400 application's requirements for continuous residence and physical presence, which of the following approaches best ensures a client's successful application and upholds professional ethical obligations? Option A. Advise the client to file the N400 application based on their general understanding of their time spent abroad, assuming USCIS will make reasonable allowances for minor inaccuracies in travel dates. Option B. Rely on the client's verbal confirmation of their travel history and advise them to submit the N400 application, trusting that any discrepancies can be clarified during the naturalization interview. Option C. Prioritize gathering evidence of the client's good moral character and community involvement, as these aspects are often heavily weighted by USCIS adjudicators, even if the continuous residence calculation is not perfectly precise. Option D. Meticulously review the client's travel documents and records to precisely calculate all periods of absence from the United States, cross-referencing these with the statutory requirements for continuous residence and physical presence as defined by U.S. Citizenship and Immigration Services, USCIS, regulations. The correct answer is D. Meticulously review the client's travel documents and records to precisely calculate all periods of absence from the United States, cross-referencing these with the statutory requirements for continuous residence and physical presence as defined by U.S. Citizenship and Immigration Services, USCIS regulations. Explanation. The scenario presents a challenge for an immigration attorney in California when advising a client on the N400 application process. The core difficulty lies in accurately assessing the client's eligibility for naturalization, particularly concerning the continuous residence and physical presence requirements, which are critical for U.S. citizenship. Misinterpreting or misapplying these requirements can lead to a denial of the N400 application, potentially impacting the client's immigration status and future opportunities. The attorney must navigate complex USCIS regulations and case law to provide sound legal advice. The best approach involves a thorough review of the client's travel history and documentation to precisely calculate the periods of absence from the United States. This meticulous examination ensures that the client meets the statutory requirements for continuous residence, generally 5 years or 3 years if married to a U.S. citizen, and physical presence, at least 30 months out of the 5 years or 18 months out of 3 years. This detailed analysis, grounded in USCIS policy manuals and relevant case law, allows for an accurate determination of eligibility and the preparation of a strong N400 application. This aligns with the ethical duty of competence and diligence owed to the client under California state bar rules and the American Immigration Lawyers Association, AILA, ethical guidelines. An incorrect approach would be to rely solely on the client's general recollection of their time abroad, without verifying the exact dates of departure and return. This could lead to an inaccurate assessment of continuous residence and physical presence, potentially causing the client to file an application they are not yet eligible for, or to omit crucial details about their absences, which could be viewed as misrepresentation. This fails to meet the standard of care expected of an immigration attorney. Another incorrect approach would be to advise the client to file the N400 application based on a best guess of their eligibility, hoping that USCIS will overlook minor discrepancies in their travel history. This is ethically problematic, as it encourages the client to potentially misrepresent facts to USCIS and disregards the attorney's duty to provide accurate legal counsel. It also exposes the client to the risk of denial and potential immigration consequences. Finally, an incorrect approach would be to focus solely on the client's good moral character and civic responsibility aspects of the N400 application, while neglecting the fundamental eligibility requirements of continuous residence and physical presence. While these other factors are important, they are secondary to meeting the statutory prerequisites for naturalization. An attorney must prioritize the foundational eligibility criteria to ensure a successful application. Professionals should employ a systematic approach to N400 eligibility assessments. This involves 1. Gathering all relevant client information, especially travel records. 2. Thoroughly researching and applying the specific statutory and regulatory requirements for continuous residence and physical presence, referencing USCIS policy and relevant case law. 3. Conducting a detailed calculation of the client's time in and out of the U.S. And 4. Providing clear, accurate, and well-supported advice to the client based on this analysis. Question 16. The audit findings indicate a potential omission on a U.S. N400 application for naturalization regarding a minor traffic citation. What is the most appropriate course of action for the auditor to ensure compliance with U.S. citizenship requirements? Option A. Recommend that the applicant disregard the traffic citation on the N400, as it was a minor infraction and unlikely to impact their application. Option B. Advise the applicant to amend their N400 application to include the traffic citation and explain the importance of full disclosure. Option C. Immediately recommend denial of the N400 application due to the applicant's failure to disclose the traffic citation. Option D. Suggest the applicant wait to see if USCIS discovers the omission before taking any action. The correct answer is B. Advise the applicant to amend their N400 application to include the traffic citation and explain the importance of full disclosure. Explanation. The audit findings indicate a potential discrepancy in the applicant's N400 application for naturalization in the United States, specifically concerning the good moral character section. This scenario is professionally challenging because it requires a nuanced understanding of U.S. immigration law and USCIS policy, balancing the applicant's right to naturalize with the government's mandate to ensure applicants meet all statutory requirements. The applicant's failure to disclose a minor traffic violation, even if it did not result in a conviction or significant penalty, could be interpreted as a lack of candor, which is a critical component of demonstrating good moral character under the Immigration and Nationality Act. The auditor's role is to identify such potential issues and ensure the application is processed accurately and ethically, adhering strictly to the INA and relevant USCIS guidance. The best approach involves proactively addressing the omission with the applicant and guiding them to amend their N400 application to include the previously undisclosed traffic violation. This approach is correct because it upholds the principle of full disclosure, which is fundamental to demonstrating good moral character. Section 316A of the INA requires applicants to prove they have been persons of good moral character for the statutory period preceding their application. While a minor traffic violation might not inherently demonstrate bad moral character, the failure to disclose it on the N400, which specifically asks about arrests, citations, and convictions, can be viewed as a lack of candor. By encouraging the applicant to amend their application, the auditor facilitates an accurate representation of the applicant's history to USCIS, allowing the agency to make an informed decision based on complete information. This aligns with ethical obligations to ensure the integrity of the immigration process and to assist applicants in meeting their disclosure requirements. An incorrect approach would be to ignore the discrepancy, assuming the violation was too minor to matter. This is professionally unacceptable because it bypasses the applicant's legal obligation to provide truthful and complete information on the N400. USCIS has discretion in determining what constitutes a lack of good moral character, and even minor omissions can lead to adverse findings. Another incorrect approach would be to advise the applicant to simply omit the information again, arguing that it was an oversight and unlikely to be discovered. This is ethically reprehensible and potentially illegal, as it involves actively participating in the concealment of information from a government agency. It violates the duty of honesty and integrity in the application process. A third incorrect approach would be to immediately recommend denial of the application based solely on the omission, without allowing the applicant an opportunity to correct the record. While the omission is serious, the INA and USCIS policy generally allow for opportunities to amend applications and provide explanations, especially for minor issues, before a final determination is made. Professionals should employ a decision-making framework that prioritizes accuracy, transparency, and adherence to legal requirements. This involves thoroughly reviewing all submitted information, identifying potential discrepancies or omissions, and then consulting relevant statutes and agency guidance. The next step is to communicate clearly and ethically with the applicant, explaining the nature of the issue and the legal implications. The professional should then guide the applicant towards the most appropriate corrective action, which in this case is amending the application, while ensuring all actions are documented. This process ensures that the applicant's case is presented accurately to USCIS, maximizing the chances of a fair and lawful outcome. Question 17. During the preparation of a U.S. N-400 application for a client residing in California, a legal representative discovers that the client was arrested for a minor offense 5 years ago, but the charges were subsequently dismissed. The client expresses concern that mentioning this might negatively impact their application for U.S. citizenship. What is the most appropriate course of action for the legal representative to ensure compliance with U.S. immigration law and ethical obligations? Option A. Advise the client to fully disclose the arrest and dismissal on the N-400 form, providing a detailed explanation of the circumstances and any supporting documentation demonstrating good moral character since the event. Option B. Recommend that the client omit the arrest from the N-400 form, as the charges were dismissed and therefore do not constitute a conviction. Option C. Focus the N-400 application solely on the absence of criminal convictions, without addressing the prior arrest or detention, as this is the primary criterion for good moral character. Option D. Suggest the client avoid mentioning any interactions with law enforcement, including the arrest, to prevent any potential complications with their citizenship application. The correct answer is A. Advise the client to fully disclose the arrest and dismissal on the N-400 form, providing a detailed explanation of the circumstances and any supporting documentation demonstrating good moral character since the event. Explanation. The assessment process reveals that navigating the nuances of the N-400 application, particularly concerning the good moral character requirement, presents a significant professional challenge. Applicants may have past experiences that, while not criminal, could be interpreted negatively by USCIS. It is crucial for legal professionals to guide applicants through these disclosures accurately and ethically, ensuring full compliance with U.S. immigration law without misrepresenting facts or omitting material information. The challenge lies in balancing the applicant's desire for citizenship with the strict legal standards set by the U.S. Citizenship and Immigration Services, USCIS. The best approach involves a thorough and transparent review of the applicant's entire history, including any past arrests, detentions, or interactions with law enforcement, even if charges were dropped or expunged. This proactive disclosure, coupled with a clear explanation of the circumstances surrounding each event and evidence demonstrating rehabilitation or good moral character since then, aligns with the spirit and letter of U.S. immigration law, specifically 8 U.S. Code Section 1427, A.3, and 8 U.S. Code Section 1101, F, define the criteria for good moral character, and USCIS policy manuals provide guidance on how to assess past conduct. Presenting a complete picture allows USCIS to make an informed decision based on all available facts, rather than discovering undisclosed information later, which could jeopardize the application. An approach that omits or downplays past arrests, even if the applicant believes they were minor or resolved favorably, is ethically and legally problematic. This constitutes a failure to provide truthful and complete information to USCIS, a direct violation of the N-400 application's sworn statements and immigration regulations. Similarly, advising an applicant to avoid mentioning any interactions with law enforcement, regardless of the outcome, is a failure to uphold professional responsibility and could lead to accusations of misrepresentation or concealment. Furthermore, focusing solely on the absence of convictions while ignoring other relevant interactions with law enforcement, such as detentions or citations that might reflect on moral character, is an incomplete and potentially misleading strategy. Professionals should adopt a decision-making framework that prioritizes full disclosure, accurate representation, and proactive explanation. This involves conducting a comprehensive background check, discussing all potential issues with the applicant, gathering supporting documentation, and preparing a clear narrative for USCIS that addresses any concerns regarding good moral character. The goal is to present the applicant in the most favorable light while remaining truthful and compliant with all legal requirements. Question 18. Operational review demonstrates that a paralegal handling multiple U.S. N400 applications is prioritizing speed to meet client expectations for quick processing. Which of the following approaches best ensures compliance with U.S. Citizenship and Immigration Services, USCIS, regulations and ethical professional conduct for naturalization applications? Option A. Conduct only a cursory review of the N400 form, focusing primarily on ensuring the applicant has signed the document to expedite the submission process. Option B. Implement a multi-stage review process that includes an initial comprehensive check for completeness, followed by detailed verification of all information against supporting documents, and a final quality assurance review before submission. Option C. Accept the applicant's verbal assurance that all information provided on the N400 form is accurate without independently cross-referencing it with the submitted supporting documents. Option D. Limit the review to identifying obvious spelling mistakes on the N400 form, assuming that any information not misspelled is factually correct. The correct answer is B. Implement a multi-stage review process that includes an initial comprehensive check for completeness, followed by detailed verification of all information against supporting documents, and a final quality assurance review before submission. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent tension between efficient processing and the absolute requirement for accuracy and completeness in immigration applications. The N400 form, specifically for naturalization in the United States, demands meticulous attention to detail. Errors or omissions can lead to significant delays, requests for evidence, or even denial of the application, impacting the applicant's ability to become a U.S. citizen. The professional's duty is to facilitate the process while upholding the integrity of the application and adhering strictly to U.S. Citizenship and Immigration Services, USCIS, regulations. Correct approach analysis. The best professional practice involves a systematic, multi-stage review process that prioritizes thoroughness and compliance with USCIS requirements. This approach begins with an initial comprehensive review of the applicant's submitted N400 form and supporting documentation to identify any obvious gaps or inconsistencies. Following this, a detailed verification of all information against supporting evidence is conducted, cross-referencing dates, names, and addresses. Finally, a dedicated quality assurance check is performed to ensure all sections are complete, all required documents are present, and the application adheres to the specific instructions outlined by USCIS for the N400. This method ensures that the application is as robust and accurate as possible before submission, minimizing the likelihood of USCIS RFE, request for evidence, or denial due to procedural or substantive errors. This aligns with the ethical obligation to provide competent representation and the regulatory requirement to submit accurate information to USCIS. Incorrect approaches analysis. One incorrect approach involves prioritizing speed by conducting only a superficial review of the N400 form and its supporting documents, focusing primarily on ensuring the applicant has signed the form. This approach fails to meet the professional standard of care by neglecting the substantive accuracy and completeness of the application. It violates the implicit ethical duty to act in the applicant's best interest and the regulatory expectation that all information provided to USCIS is truthful and complete. Such a superficial review significantly increases the risk of application denial or lengthy delays due to USCIS identifying errors that a more diligent review would have caught. Another incorrect approach is to rely solely on the applicant's verbal confirmation that all information is accurate without independently verifying it against provided documentation. While the applicant is responsible for the truthfulness of their statements, a professional has a duty to ensure the submitted application reflects the evidence provided. This approach risks submitting an application with factual discrepancies that could be easily identified by USCIS, leading to negative consequences for the applicant. It bypasses a critical step in ensuring the integrity of the application and fails to uphold the professional standard of diligence. A further incorrect approach is to only review the N400 form for obvious typographical errors, assuming that any information not clearly misspelled is correct. This overlooks the possibility of factual inaccuracies, incorrect dates, or omissions of required information that are not necessarily typos. The N400 requires specific details about an applicant's history, and a focus solely on spelling misses critical substantive elements that USCIS scrutinizes. This approach is insufficient for meeting the regulatory requirements for a complete and accurate naturalization application. Professional reasoning. Professionals should adopt a structured, risk-averse approach to N-400 applications. This involves establishing clear internal protocols for review that include multiple checks and balances. The process should be designed to catch potential issues before submission, rather than reacting to USCIS requests for evidence. Professionals must continuously educate themselves on the latest USCIS guidelines and requirements for the N-400 form to ensure their review processes remain current and effective. When in doubt about any aspect of an application, it is always best to err on the side of caution and seek clarification or additional documentation. Question 19. Analysis of an applicant preparing to file their N-400 application for naturalization in California reveals they have been relying on information from an online immigration forum to understand specific eligibility requirements. The applicant believes this information is accurate and sufficient for their application. What is the most responsible course of action for this individual to ensure compliance with U.S. citizenship requirements? Option A. Proceed with the N-400 application using the information gathered from the online forum, assuming it reflects current U.S. immigration law and USCIS procedures. Option B. Submit the N-400 application with the information from the online forum and be prepared to correct any errors if USCIS identifies them during the review process. Option C. Rely on the information from the online forum as a primary source, cross-referencing it with other unofficial online resources to confirm its accuracy before submitting the N-400. Option D. Immediately consult the official U.S. Citizenship and Immigration Services (USCIS) website for the most current N-400 form and instructions, and seek clarification from USCIS directly or a qualified immigration attorney if any questions remain. Correct answer is D. Immediately consult the official U.S. Citizenship and Immigration Services (USCIS) website for the most current N-400 form and instructions, and seek clarification from USCIS directly or a qualified immigration attorney if any questions remain. Explanation. This scenario presents a professional challenge due to the critical nature of accurately completing the N-400 form, which directly impacts an individual's eligibility for U.S. citizenship. Misrepresenting information, even unintentionally, can lead to severe consequences, including denial of the application and potential future immigration issues. The applicant's reliance on incomplete or outdated information from a non-official source creates a significant risk of error. Careful judgment is required to ensure all information provided to U.S. Citizenship and Immigration Services (USCIS) is truthful, accurate, and current, as mandated by U.S. immigration law. The best approach involves proactively seeking official guidance and verifying all information directly with USCIS. This means consulting the most recent version of the N-400 form and its instructions available on the official USCIS website. And if there are any doubts or complex circumstances, scheduling an appointment with a USCIS representative or consulting with a qualified immigration attorney. This approach is correct because it prioritizes accuracy and compliance with U.S. federal immigration regulations, specifically the Immigration and Nationality Act, INA, and USCIS policy manuals, which require applicants to provide truthful and complete information. Relying on official sources ensures the applicant is working with the most up-to-date requirements and procedures, thereby minimizing the risk of misrepresentation. An incorrect approach would be to proceed with the application based solely on the information from the online forum. This is professionally unacceptable because online forums are not official sources of information and can contain outdated, inaccurate, or misleading advice. Relying on such information constitutes a failure to exercise due diligence and could lead to the submission of false information, violating the requirement for truthfulness under U.S. immigration law. Another incorrect approach would be to assume that because the information was found online, it is automatically correct and sufficient. This demonstrates a lack of critical evaluation and an over-reliance on unverified sources, which is a failure to meet the standard of care expected when dealing with legal and immigration matters. A third incorrect approach would be to ignore the discrepancy and submit the form with the potentially incorrect information, hoping it will not be noticed. This is ethically and legally unsound, as it involves knowingly submitting information that may be false, which is a direct violation of U.S. immigration law and can have severe repercussions. The professional decision-making process for similar situations should involve a hierarchical approach to information gathering. Always prioritize official government sources, USCIS website, official forms, USCIS contact centers. Then consult qualified legal professionals if needed, and treat unofficial sources like forums or anecdotal advice with extreme caution, using them only for general understanding and never as a basis for factual submission. Question 20. The review process indicates that a U.S. lawful permanent resident applying for naturalization in California has discovered a calculation error in their federal income tax return from 3 years prior, resulting in an underpayment of approximately $1,500 in taxes. The applicant has not yet amended the return. What is the most appropriate course of action to address this issue in their N-400 application process? Option A. Amend the federal income tax return to reflect the correct income, but do not pay the underpaid tax, interest, or penalties as the error was unintentional. Option B. Amend the federal income tax return to reflect the correct income, pay the underpaid tax along with any applicable interest and penalties, and be prepared to provide documentation of these actions to USCIS. Option C. Assume the error is minor and will not be discovered by USCIS, therefore taking no action regarding the tax return. Option D. Disclose the error to USCIS during the naturalization interview, but take no further action to amend the tax return or pay the underpaid tax. The correct answer is B. Amend the federal income tax return to reflect the correct income, pay the underpaid tax along with any applicable interest and penalties, and be prepared to provide documentation of these actions to USCIS. Explanation. The review process indicates a scenario where an applicant for U.S. citizenship through naturalization, Form N-400, has made a calculation error in reporting their income for tax purposes over a period relevant to their good moral character determination. This is professionally challenging because the applicant's financial honesty and adherence to U.S. tax laws are critical components of demonstrating good moral character, a prerequisite for naturalization under the Immigration and Nationality Act. A misstatement, even if unintentional, can raise concerns. Careful judgment is required to assess the nature and intent of the error and its impact on the applicant's eligibility. The correct approach involves the applicant proactively and accurately correcting the tax filing and providing clear documentation to U.S. Citizenship and Immigration Services, USCIS. This demonstrates a commitment to rectifying mistakes and upholding legal obligations. Specifically, the applicant should amend their tax returns to reflect the accurate income and pay any resulting tax liability, interest, and penalties. They should then be prepared to explain the error and the corrective actions taken to the USCIS officer during the naturalization interview, providing copies of the amended returns and proof of payment. This approach aligns with the INA's requirement for applicants to demonstrate good moral character, which includes honesty and compliance with laws. By taking these steps, the applicant shows they are not attempting to conceal information and are actively working to be in full compliance. An incorrect approach would be to ignore the error and hope it goes unnoticed. This demonstrates a lack of diligence and potentially an intent to mislead USCIS, which directly undermines the good moral character requirement. Failing to amend tax returns and pay the correct amount of tax is a violation of federal law and can be interpreted as a failure to comply with the law, a key aspect of good moral character. Another incorrect approach would be to attempt to explain the error without taking any corrective action, such as amending the tax return. While honesty is important, simply admitting a mistake without rectifying it does not demonstrate a commitment to fulfilling legal obligations. USCIS expects applicants to take concrete steps to correct past errors, especially those involving financial and legal compliance. A further incorrect approach would be to provide incomplete or misleading information about the income discrepancy when questioned by USCIS. This would be considered an act of dishonesty and could lead to a finding of lack of good moral character, potentially resulting in the denial of the N-400 application. The professional reasoning framework for such situations involves prioritizing transparency, accuracy, and proactive compliance with U.S. laws and USCIS requirements. When an error is discovered, the professional decision-making process should involve 1. Identifying the nature and potential impact of the error. 2. Consulting relevant legal and tax regulations. 3. Taking immediate corrective action to rectify the error and ensure compliance. And 4. Preparing to provide clear, honest, and documented explanations to the relevant authorities. This systematic approach ensures that the applicant's actions reflect a genuine commitment to good moral character and legal adherence.